The Michigan City of Detroit is now in session. The Honorable Aliyah Sabree presiding. Good morning, Judge.
Good morning, everybody.
Morning. Good morning.
Only one person. John Tosh.
I do believe it's Sutton. Good morning, Council. You are checking in for Sutton, correct?
Madam Clerk, Judge. No, I'm checking in for John Tosh Green.
All right.
I don't know why I guess that.
You did a good guess. Here.
Okay. Give me 1 second and I will call you.
Perfect.
Yeah, there's supposed to be an OIC. Now my client's not gonna come. She said she had to, but I have a couple of PCCs I can do. Good morning, Judge. How are you doing?
Good. I got your motion too.
Oh, okay, great. I have a couple of PCCs. I think I have here. Probably those. You have more waiting. Oh, I do. Okay, great.
Your motion on Sutton, we're gonna have.
Oh, no, that's on as a CCC, but it's separate.
Yeah.
Okay, that's it.
Oh,
So,
okay.
the motion on Sutton, you're asking for some time? Is that what you're doing?
Yeah.
Okay, then I'll ask them to not come in. That's what they're gonna
Yeah.
do. If you wanna deal with that now, then I can tell them to cancel it, right?
Yeah, you can tell me cancel. Because it won't be a hold today. for
Okay,
sure. Basically,
alright.
right.
Yeah, all right, good, I couldn't get my printer to work.
I see that you're asking for a time. No, it's not gonna be. I read the transcript.
Then, I'll do my PCCs, but then do we wanna come back for a motion hearing on that instead of rescheduling the exam first? Whatever, we can.
We can do the Sutton, that shouldn't take long.
Okay.
And then you do PCC and then whenever the OIC gets here.
Okay.
Yeah, we can take this. Okay.
Sounds good.
Okay, we're on Zoom, everything. Don't have a recorder, but we have Jabs working, so that's what we're gonna have to rely on our recording system. So we can get moving today. I have.
Say it again, Judge.
Rico Sutton.
Yes, Judge, I have. I'm trying to pull on. Rico Sutton's on the top.
Okay. Okay, we are on the record. This is People of the State of Michigan versus Rico Edward Sutton, 2355920. Mr. Sutton is charged with 1 count of police officer fleeing forgery vehicle code, penal code. Count 2, police officer assaulting, resisting, and obstructing. The individual for the 4th offense notice is set for exams and appearances.
Edwin Tawaki, P54828, appearing on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by now, about to be 82355 here on behalf of Mr. Rico Sutton. I asked to waive his appearance.
I will waive his appearance today. I did receive a motion to dismiss from you, Attorney Phelps, based off of the people issuing this case after dismissing without prejudice for insufficient evidence. The case was heard by Judge Stanford Jones, is that correct?
That's right, Judge.
Okay, and Mr. Swalk, you're asking for some time to respond?
Yeah, we would like about 7 days, Your Honor.
Okay, all right, so let's see, today is the 2nd. No, it's not, it's the 3rd.
Yeah.
Does the 10th or 11th work for either day?
For a motion hearing only, Judge, or do we? That's a motion hearing, I can reiterate. We're gonna also schedule through that. We kind of like.
Let's do motion here.
And then just a heads up, I will be leaving, I'm off starting the 13th through the rest of the month. So from there, just so the board is aware of my schedule. But if we're just doing a motion hearing, either day works.
11?
Okay. Do You want to do 8:30 or 9:00?
8:30 is preferable for
Okay.
me.
Okay.
I'm here. Oh, wait, what's on?
Make sure you're here that day.
Yeah, I just,
Okay.
okay, it's Monday between the holidays. I apologize. Can we do the 10th? I'm here on the 10th.
Anytime on the 10th first.
Anytime? 8:30?
Judge, would you like myself and Mr. Sutton in person, or is it sufficient for that?
Zoom is sufficient. You don't have- okay.
Thank you, Judge.
What, was there a transcript?
Yeah, I got it.
Okay. Okay. Are you guys?
Yeah.
So this morning?
But no problem, I know I filed it yesterday. Thank you. Okay, I will be back shortly.
Okay. All right, now to Miss John Thomas Green. Which is saying probably. So the gentleman where it says Tasia Green, what is your name, sir?
John Tosh Green. John Tosh Green.
Okay. Okay, we're on the record as people of the state of Michigan versus John Tosh Green, 2357324. Mr. Green is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons, felony firearm, count 3, assault with a dangerous weapon, felonious assault, count 4, weapons, felony firearm. Set for an exam today. Experiences?
Edwin Tawaki, P5488, here on behalf of the people.
And Judge, good morning to you and your staff. Vincent Pasha, P76506, Judge, retained counsel with and on behalf of John Tosh Green, who's present via Zoom with no objection to appearing remotely.
Got you.
And Mr. Green, can you unmute your device and state your name, please? Unmute your device and state your name.
Sorry, Your Honor. John Tosh Green.
Thank you. Okay, Attorney Haitian, is it correct that you were just retained yesterday on this case?
Yes, actually, Judge, Saturday.
Saturday, okay. All right. Well, Mr. Green, find time to retain counsel. Today's exam, I'm sure witnesses are on their way, but because you have new counsel, I have to use the opportunity to prepare for your exam. Can you all actually, Mr. Milwaukee, use the discovery?
Yeah, if I can have his P number, your P number, sir.
Of course, 76506.
Thank you. We will send the discovery to you.
Excellent. Thanks much.
Okay, so I'd like to set this for a PCC on Wednesday.
Judge, I'm in the building on Wednesday. That's just fine.
Okay. And Mr. Green, even though your attorney's in the building, you can still log on Zoom for the PCC on Wednesday at 8:30, okay?
Yes, ma'am.
Judge, if I could, please, I just want to address right now. I know I'm coming in and just barging onto the docket, but he has a job interview lined up and he's currently on a house arrest with the GPS tether. If I could just touch on that.
Sure.
All right, Judge, he's 35. This is his first contact with the criminal justice system. He has some minor traffic issues in the past. He's a high school graduate with college experience at Wilberforce University in Ohio, as well as Wayne County Community College. He's a member of the Perfecting Church on Van Dyke in Detroit, father of a 6-year-old daughter, stepfather of a 6-year-old and another 4-year-old, with family ties. Although this is an assaultive charge, I understand that allegation is assaultive. There's no allegation that a firearm was actually discharged. At this point, I'm simply requesting that if the court is to continue the GPS tether, I'd ask the court to continue or consider removing it. But if the court is to continue that, to allow him to be able to move with certain hours. He has a job interview lined up at Alliance Temp this coming Thursday. He cannot appear at that job interview unless he's able to leave his residence. And I would also note that currently he's staying at his mother's residence, or I'm sorry, his father's residence, because apparently the 19270 Telegraph Road, his residence is within the exclusion zone of the store that this allegedly took place at. So I don't know if there's a way to allow him back into his own residence. That's a unique one for me. I've never seen that happen where someone can't actually go home unless it's a domestic case where there's a witness or a complainant that doesn't allow them to reside in that home. So I'm hoping that he can go home or have these conditions loosened to some extent. I understand the need for public safety, but I have to think that there's a less restricted means to accomplish that than home detention at a place that's not his residence.
Okay, who lives at the location 19270 Telegraph?
That would be John Tosh and his girlfriend and their 3 children.
Anything from the people?
Yes, Your Honor, loosening of the tether, we're going to.
I didn't hear you.
I'm sorry, Your Honor. Loosening of tether restraints for him to go to the job interview, we don't have a problem with. As long as he has absolutely no contact with that in that area with the store, I can understand that. But this without saying more, what I've seen so far was kind of disturbing.
Okay, so I will allow Mr. Green to go back home. First, I'm gonna allow him to go back home to 19270 Telegraph. But of course, that means still no contact with the gas station in question here, or where the incident happened, allegedly happened. No contact with the complaining witnesses, indirectly or directly. I will allow for you to leave the house for job interviews, any medical or any court appearances or meetings with your attorney. And I'll make sure I write all this down to the tether unit. As of now, I'm not going to lift the house arrest, but I will allow you to leave the house to seek employment and to work. So if you get that job, you need to contact your attorney and I will update your times. So if you're working from 10 to 6, I will make your curfew from 8 a.m. to 8 p.m. so that you can work. But I need to see that you have actual employment before I lift the house arrest.
Understood, Your Honor. Thank you much. Judge, do you want me to submit an order on that, or is the court going to submit an order?
I'm already doing it right now.
Perfect. And just time for the PCC, Judge. I'm in an exam with Judge Jefferson at 9 o'clock. So if we can maybe do 10 o'clock, that'd be fine.
We start at 8:30.
I could do 8:30, that's fine.
Yeah, be the first one in here. You're in person, so you just walk in, we'll be here.
Sounds good, Judge. I'll be there.
Okay.
Thank you.
All right, you're welcome.
And thank you, counsel.
Oh, you're welcome.
John Tosh, you can log off. I'll call you. See you all.
Okay,
Happy 4th.
Oh, Mr. Green, before you log off,
Yes, ma'am.
you have the address or the accurate name of the temp agency?
The name is Alliance Temp. I don't have the address offhand right now, Your Honor. I apologize.
Is it in Detroit?
No, it's in Fraser, Michigan, or if I believe it's Fraser, not too far from Roseville, Michigan.
Okay, that's all I need.
Yes, ma'am.
And if you get the job, make sure you contact your lawyer and let him know so he can update the court, okay?
Okay.
All right, you can log off.
Thank you.
You're welcome.
This was my dad.
I have two bad areas now.
The person listed on the iPhone, could you unmute your device and state your name? You don't let me talk to you. Just get me nowhere. The person on the iPhone, if you hear the courtroom, could you unmute your device and state your full name, first and last, please?
Antonio Hayden.
All right. Do you hear Antonio? Did you say Hayden, sir?
I didn't hear you, ma'am.
Oh, Antonio, you're Air Attorney Johnson's client. Okay.
All right.
Let me read. Thank you. Thank you. The person on the, it says Tino, please unmute your device and state your first and last name. Person listed as Tino, Tinno. Please unmute your device and state your first and last name. Thank you.
What's your name? Lieutenant Antonio Akins.
How you doing, ma'am?
I'm fine, how are you, sir?
Okay.
This is case 2357551, the people of the state of Michigan versus Antonio Akins, charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 3, controlled substance, delivery, manufacture, methamphetamine. Count 4, 5, and 6, weapons, fucking firearms, set for a probable cause conference today. Appearances.
Edward Milwaukee, CR438, appearing on behalf of the people.
Good morning, Your Honor. May it please the court, Dwayne Johnson, P 41842, on behalf of Mr. Antonio Akins. We are waiving an in-person appearance at this time, Your Honor, and we are willing to appear by Zoom. Mr. Akins, state your name, please.
Antonio Darrell Akins.
And Attorney Johnson, do you have discovery?
I have partial discovery. I have the paper discovery, but no digital discovery, no body cams or anything like that. So I would like to receive those.
Of course, we have, fillers out with the OIC, see where the control.
I couldn't hear you. I couldn't hear what you said.
I'm sorry, we have contacted the OIC to obtain that, digital evidence.
Okay. So I'm assuming I'll receive it shortly. Is that correct?
I hope so.
Okay.
No control over the OIC.
Your Honor, we do want to hold a preliminary exam on this matter.
Okay, let's do a date here.
Now, Your Honor, I am before you on the 17th at 9 o'clock. If you want, if 10 o'clock would work, that would be fine for me if it works for the court.
That's fine.
Yeah.
Okay, let's do 17th at 10 o'clock.
Thank you, Your Honor.
You're welcome. Mr. Akins?
Yes.
Before you log off, I have to put you on notice. You are to be in person at 36th District Court on July 17th at 10 o'clock a.m. Do you understand that?
Yes, ma'am.
Okay, you're all set. You all both have a good day.
Everybody have a great week now.
Thank you. I'll remove you, Mr. Akins. Everybody ready to go for 9 o'clock?
Right.
Sir, what's your name? In the Wayne County
Yaya
Jail?
Kita. Yaya Kita.
Okay, Attorney Hamilton?
Yes.
Do you need to speak to Mr. Tito before you go on the record?
I didn't hear you. Say that again.
No,
Judge.
Your Honor.
Oh,
I just asked if your lawyer needed to speak before we went on the record.
no, I haven't spoken my lawyer at all, not one time.
I can speak with him then in a breakout room.
Here he is, that's my fault. No. We have a female, Ebony, said judge.
Is your boss man?
On that. Bill, here, so, yes.
Thank you. I won't give you. Oh, you didn't tell me that. All right, thank you.
You were busy having good business.
Serena, it's so hard to find that help. Argue it again.
Mr. Kita, can you hear the court? Mr. Kita? Mr. Keita, Mr. Yaya Keita, I need you to respond. Were you able to talk to Mr. Keita in the breakout room, Attorney Hamilton?
Yes, I was able to speak with him.
Good morning, Mr. Good morning. New dates, we don't have a judge that they open, so this is.
This is a current Judge Sabree. Is this video for 30? Good, how you doing? We're trying to get Mr. Keita back on the screen. Yaya Keita, the judge. It's a male. He was on the screen and he disappeared. Wait a minute, I called the wrong place. This ain't the county, is it? Okay, thank you.
Ebony, I slid it up, it doesn't have anything on it.
What division is this?
3.
This division 2 on the screen.
Yeah, that's division.
Division 2. I don't even see, oh, here go video division 2. 224, what does that say? You got your glasses on. I'm sorry.
7968.
Great.
Good morning, this is Officer Carson in Judge Sabree's courtroom. Mr. Yaya Keita was on the screen and then he disappeared. Could we get him back on the screen? Hello? Okay, yes, thank you.
Okay, thank you. Thank you. Just on an order. Thank you.
Did you call?
Mr.
Oh, no, I
That's what I said.
I called the jail to get Mr. Keita back on.
You're on
the
the show
screen.
right now, Mr. Bond. I don't know why.
You're not in no room, right?
Mr.
Keita.
That's the screen right there on the left.
Yeah, maybe they're trying to work it out, so I called. You're welcome, babe. Hey, excuse me, you got your days and stuff. No. Those are days and stuff. Your days.
Okay, while we're waiting for the Wayne County Jail to fix their device, handle Evan Richardson. Case 2357519, the people of the state of Michigan versus Ebony Renee Richardson. Ms. Richardson is charged with count 1, weapons carried concealed, count 2, weapons taser, possession or sale of, count 3, felony commission with motor vehicle adult advisory, set for a probable cause conference today. Appearances.
Edwin Sawaki, P54828, appearing on behalf of the people.
Good morning, may it please the court, Harry Boffman, P55052, on behalf of the defendant. Your Honor, we'd ask that the matter be set for a probable cause conference. I am not available for a conference next Monday, and I would ask for a next best action date. Can we do the first week of August? I don't have any discovery at this time.
For an exam, or you mean, or an exam, correct?
Well, yeah, I don't think that we're gonna waive.
Okay, let's start with discovery. Did you provide discovery?
Yes, paper went out on June 28th. Digital went out on June 29th.
You said that digital was sent?
Yes.
And to the individual, as Robin Richardson, can you state your name, please?
Ebony Richardson.
I have received discovery and I can confirm that. Thank you.
Okay. So it's set for the 10th for an exam. You said you're not available next week?
I'm not. I won't be back home until the 16th.
Okay, what about the week of the 16th then?
One moment while I check my schedule. I am free on the 17th, Your Honor, as long as we're on Zoom.
No, the exam will be in person.
Oh, yeah, I do have a number of Zoom hearings. Can we do the exam later in the morning? Say 11:30?
So the problem with 11:30 is they never start at 11:30.
Okay.
They go right to staff lunch and then I have to deal with unions. So if everyone would actually come on time, then I would love 30, but it never, ever works out that way.
Okay. Is Monday the only date?
No, the 18th.
Any day that week? Can we have the 20th, please? I'm available on that date, Thursday, the 20th.
Okay. See you at 9 o'clock, please.
Of course, Your Honor. It'll be my pleasure to be on time.
Okay. Ms. Richardson, your exam has been set for July 20th at 9 o'clock a.m. in person at 36th District Court. Do you understand that, Ms. Richardson?
Yes, Your Honor.
Okay, you're all set. You all have a great week.
Have a great day, everybody. Bye now.
Thank you.
Thank you.
Okay. Mr. Kita, can you hear us? Mr. Kita, can you have the deputy unmute the device so that or case can be called?
You guys hear me now?
I can hear you, yes. Okay, we're back on the record on Yaya Omar Kita. Actually, we're not on the record. We were not. 2357158, people of the state of Michigan versus Yaya Omar Kita. Mr. Kita is charged with one count of stolen property, receiving and concealing a motor vehicle as defendant number 1. Set for a probable cause conference appearances.
Edwin Zawaki, P 54828, appearing on behalf of people.
And Vanessa Hamilton, P82107, on behalf of Mr. Kita, who joins us from the Wayne County Jail.
You have discovery, Attorney Hamilton?
I do have discovery, Your Honor, and I'd just like to set a preliminary exam date.
Okay.
And also make a bond argument.
Okay. Does July 11th work?
Yes, that works.
Okay. I like to schedule it first, 9 o'clock.
That works, yeah.
Okay, and go ahead and address bond.
Just in terms of bond, Your Honor, my client is 19 years old. He did have a job that he was working on. He's not sure if he will be able to return to that job anymore. But he was also in the process of getting his GED. And so he would like to continue on that path so he can actually earn his GED. He does do a lot of taking care of, he has a older and a younger sibling that both have autism. And so he spends a lot of time at home helping and assisting taking care of them. So we'd ask that he be allowed a personal bond. If the court's very concerned about him coming back, a GPS tether, but ideally just a personal bond.
He already has a personal bond, 5,000 personal.
Okay, well then in that case, never mind, Your Honor, I apologize.
Mr. Keita, do you have a hold on another case?
Yes.
Okay. All right, and he has a personal bond on this case, so it wouldn't be this one holding him in custody.
Okay. All right, thank you.
Mr. Keita, your exam has been set for July 11th at 9:00 a.m. You'll be brought over to Wayne County, from the Wayne County Jail if you're still in custody, okay?
Okay.
You're all set.
All right.
Thank you.
What's going on recent? I don't know. I couldn't hear that part. Just your client or just? You want to just look over the file for yourself?
Waiver.
Oh, okay.
That's okay. Yeah. There you go.
Attorney Wazak, are you ready on your client's case?
Yes, Judge, we are ready.
Okay, I'm bringing him out now.
Thank you.
Okay, we're on the record. This is the people of the state of Michigan versus Davion Brown, case 2357540. Mr. Brown is charged on this case with count 1, robbery armed, count 2, robbery armed, count 3 and 4, weapons, stony firearms set for a probable cause conference today. Appearances.
Edwin Sawaki, P5482A, appearing on behalf of the people.
Good morning, Your Honor. My name is Daniel Wazak, P35225, on behalf of Mr. Brown, who appears via Zoom from the Wayne County Jail.
Mr. Brown, can you state your full name for the record, please?
Davion Brown.
Okay, Attorney Wazak, you have discovery?
I have written discovery, Judge. I'm having trouble opening the digital. I'm going to work with the prosecutor on figuring out how to open that stuff up.
Okay.
But I do have written, so I'm ready for the exam on the 10th.
Okay, how about 11 o'clock? We have 2 10 o'clocks scheduled. So 11 o'clock on the 10th?
11 o'clock is fine if it's good with the court.
Okay. July 10th at 11 o'clock.
And then if I could, Judge.
I was letting him know this exam day. Mr. Brown, your exam date is July 10th at 11 o'clock in person at 36th District Court. And what were you saying, Mr. Wazak?
We'd like a pretrial services report for the next court date. I understand without hearing any testimony at this point, you would not be able to consider a bond reduction.
Okay, I will order that. It should be ready. Hopefully it'll be ready by the time the exam comes. It has a bond determination hearing on the 26th. Okay, yeah, I'll order the DSU report and hopefully that'll be ready when the exam is here.
Thank you.
You're all set, Mr. Brown? Mr. Brown,
Yes,
did you hear everything that's going on?
the microphone keep going in and out.
Okay, so your attorney just set your exam date for July 10th at 11 o'clock in 36th District Court in person. You understand that?
Yes,
Okay, he also wants to address your bond. So he asked if I order what we call a DSU report. So what that will do is provide you with information after they interview you to determine whether or not your bond should be adjusted or lowered. So I'll have that information with the hopes I'll have that information on your exam day on the 10th. You understand?
got you. Yes,
So
ma'am.
today, nothing is changing with your bond, but it may change depending on the report. When your attorney argues bond, when you're in person, okay?
Yes, ma'am.
So you're all set for today. I will see you in person on the 10th. Okay. You're just handling Everett, correct?
Correct.
Okay. You're handling Grimes. Correct. And Dreesen. That's the other.
No, Greason's a waiver I can handle.
Okay. So I wanted to do Everett, but they're not in here. So I'll do Dreesen and Grimes. Okay. I know you're a hope. I didn't know that. Okay, we're on the record. This is people of the state of Michigan versus DeAndre Samuel Grimes, 2356436. Mr. Grimes is charged with one count of weapons carrying concealed set for an exam. Appearances?
Edwin Milwaukee, P5482A, hearing on behalf of people.
And good morning, Your Honor. Good morning, Madam Clerk, Madam Court Reporter Jonathan Roberts, P86428, on behalf of Mr. Grimes, who stands behind me. Mr. Grimes, could you please state your name for the court?
DeAndre Grimes.
Good morning to everybody. Are the people ready to proceed?
Yes, Your Honor.
Okay, call the first witness if there's no preliminary matters.
No preliminary matters for the people.
None from the bench, Your Honor.
People call Officer Brandon Eli.
Mr. Grimes? Stop. Make sure I have the name right. Grimes agrees.
Brandon Ely. That's it. Yeah, Ely.
Swear to tell the truth, don't you do?
I do.
Make sure you speak up in the microphone when you sit down. Whenever you're ready.
Ma'am.
Thank you, Your Honor. Officer, can you state your name and occupation for the record, please?
Yes, Officer Brandon Ely. I work at 12 Precinct Ceasefire Unit.
And how long have you been with the?
I've been with the department 4.5 years.
Were you on duty April 13th this year?
I was.
Were you in the area of East Lafayette Boulevard, Detroit County Plain?
I was.
What were you doing in that area?
Me and my partner were working a overtime detail, gun prevention detail downtown.
And while in that area, what did you observe?
In this particular area, during the course of our duties, we observed a vehicle, it was a Ford Fusion with front tinted windows. That's what alerted me to the vehicle. After that, I ran the vehicle's plate and observed that the vehicle was not insured.
And you were with a partner at that time?
I was.
And who would that be?
That's Police Officer Anthony Harris.
And once after you ran the lien and filed no insurance, what did you do next?
At that time, I advised my partner of my observations through lien. He initiated a traffic stop, or I should say my scout initiated a traffic stop on this vehicle, and the vehicle complied and pulled over to the right side of the road.
Once the vehicle was stopped, did you approach the vehicle?
I did. I approached on the passenger side of the vehicle.
And what occurred next?
At that time, I advised the passenger, the front seat passenger and rear seat passenger to roll their windows down so I could observe what my partner and the driver were communicating or observe their conversation take place. At that time, they complied. My partner got up to the window and began asking the driver certain questions.
Objection, Your Honor. Lack of foundation. Specifically, what the contents of that conversation were from the partner.
He said just observe his partner asking questions.
Yes, Your Honor, just ask if there be some foundation established that he was able to hear that conversation.
He said he rolled the windows down so that he could hear his partner's questioning. Did you say that?
I did.
So I think it'd be, you're objecting in the event that more questions are asked about the content of the conversation or based on what he already said?
Based off of what he's already said.
Okay, response from people?
Were you able, I can ask another question. Were you able to hear the conversation clearly between your partner and the defendant?
I was.
Did the defendant indicate that he had a driver's license?
Well, my partner asked the defendant if he had driver license, registration, and insurance, and the driver of that vehicle stated he did not have a driver's license.
What, was he asked whether or not he had a CPL?
I'm sorry, what?
Was he asked whether or not he had a CPL?
He was.
And what was his answer?
His answer was no.
After that, what happened next?
So after my partner asked him if he had a CPL, that was after observation, after the defendant had already answered another question that my partner had asked.
And what was that question?
My partner asked him if there was anything in the car that he should know about concerning contraband or firearms.
And what was the defendant?
The defendant stated that there was a firearm inside the car.
Is the defendant in the courtroom today?
He is.
Could you indicate his location and an item of clothing?
Yes. He's black male right there, short dreads, wearing a red, looks like Adidas jumpsuit.
Let the record reflect that the witness is identified as the defendant.
Can I have both counsel? And for the record, yes, it's so reflected. Okay. Back on, we had a very brief sidebar discussing some information that you can provide to Robert's client, which I do know. Is that fair?
That's fair.
Fair for defense, thank you.
All right. You may continue. I did like on the record that the defendant has been identified.
Thank you. This is defendant, he did not have TPL.
Correct.
What occurred next?
At that time, my partner, removed the driver, the defendant from the vehicle, detained him at that time. I had the front seat passenger and rear seat passenger both exit the vehicle. They were detained at that time, and we had to move over to the front of our scout car behind the subject vehicle. At that time, I conducted an inventory search of the vehicle.
Did you find any?
Yes.
And what did you find?
I located a firearm in the center console where the defendant was reaching as we got up to the stop.
Objection, Your Honor. Lack of foundation as to the reaching, I'd ask that actually be testified to.
Have a response?
I'll go back, question on that.
When I'm asking for a response, it doesn't mean that I'm agreeing with you, I'm just asking for a response.
Oh, okay. Not really, no response.
Were you gonna say something?
I'm just gonna move to strike the portion of the testimony about the reaching until that's established. The proper foundation's been laid.
Well, I think he's testifying, saying that he saw the defendant, he's saying that I saw him reach for the gun. It was after the fact, but it's still testifying. Mr. Sawaki, can you just point it out, please?
Sure. Officer, you indicated that you saw the defendant reach for the weapon. When did that occur?
No, that's not what I was saying. What I was saying was as we approached the vehicle, I had the occupants of the vehicle roll the windows down. My partner gave him verbal commands to stop reaching in the center console. At that time, I observed him reaching in the console. This was before a firearm was stated to my partner, but this was in the same area that the firearm was later located that I recovered and observed in the center console of the vehicle.
What type of weapon was it?
I believe it was a black 9mm Taurus of some sort.
Was it loaded?
It was loaded.
And did you run a lien regarding that weapon?
I did. I ran the firearm through lien and the offender through lien.
And what were the results?
For the offender did not have a CPL and not have a valid driver's license, obviously. And for the firearm was not registered to anyone.
What was done with the weapon and the ammunition?
The firearm was taken back to our precinct, placed on evidence, given an evidence tag, and transported to the 11th precinct to be placed on evidence.
I have nothing further, Your Honor.
Good morning, Officer Ely. How are you doing?
Good morning, Counsel.
You had mentioned at first that you're part of a gun prevention unit. Can you explain what that is?
I don't know if you want to use those terms with it, but it's a ceasefire unit. It's a deterrent to prevent young individuals from possessing firearms illegally in the city of Detroit. We try to prevent it through different acts, both law enforcement and non-law enforcement sides of it.
And one of those acts would be traffic stops, correct?
Yes.
Now, in this case, you had mentioned that you were tipped off to this vehicle because the windows were tinted, specifically the front windows were tinted.
I wouldn't say tipped off, but I observed the vehicle had tinted front windows.
And what's the standard for tinting, to your knowledge? terms of when it's legal versus illegal?
To my knowledge, the state of Michigan is 0 to 10 on the front windows, front driver windows, driver, passenger of the front vehicle. Nothing on the windshield unless it's a sun strip. I believe that's 5 inches. And I do believe they just made, rectified it where they have a sun strip now on the driver and passenger side of the window. I don't know how many inches that is.
And you're saying that you saw tint on the front window. That's why you first started running lean on the car.
And that's what brought my attention to the vehicle.
So how long were you following the car until the traffic stop was initiated?
I'd have to look at my body cam to exactly tell you how long we were behind the vehicle. But I believe we were at an intersection and the vehicle passed in front of us. And that's when we observed, or when I observed the violation. So
it was going
less than 30 seconds, I would say I was behind the vehicle before we initiated the traffic stop.
And the vehicle you're saying was going across from you at that intersection?
I believe so. Like I said, I have to review my camera, but I do believe we were at the intersection when that happened.
And you were the one who recovered the gun, correct?
I was.
And I determined it was not Mr. Grimes' gun?
Yes.
The car was registered to another individual, correct?
I don't recall that the portion of the lien.
Do you know whether the car registration, you said there were 2 occupants in the car, was one of those occupants the person whose car was registered to? Do you remember?
I don't.
Did your partner at any point ask when Mr. Grimes learned that there was a gun in the car and knew that there was a gun?
You're asking me if my partner advised me of that?
Whether he advised you or he asked Mr. Grimes himself when Mr. Grimes knew that there was a gun in the car?
Yeah, I don't recall any conversation of that taking place. Like, again, I don't even know how I can testify to that unless I observed, but I didn't observe that conversation to the best of my knowledge.
So to the best of your knowledge, you didn't hear it?
Yeah, I don't remember hearing a conversation of that nature.
For the inventory search, officer, what did you specifically inventory?
I inventoried the vehicle, but at the time of me searching the vehicle, because of his because of him already making it known that there was a firearm in the car and he was not allowed to possess a firearm or conceal a firearm, I went to the driver's side of the vehicle first and began my inventory from that point forward.
So again, officer, what specifically did you inventory in the car?
The vehicle, the inside of the vehicle.
So in inventory, officer, you're aware you have to log what you find in the car, correct?
You have to log to an extent of what's in the car, valuables, miscellaneous items, anything like that would be documented on a tow card.
So I'm asking what you inventory within the car.
You're gonna have to rephrase that. I inventoried the inside of the vehicle and all of its components.
And I'm asking what specifically did you find in the car outside of the car?
Nothing that would be considered illegal to have.
Do you remember what you cataloged in the car outside of the car?
I don't.
Did you bring a tow card today?
Did I bring a tow card? No.
What steps did you take before starting the inventory search? Did you call to impound at first, or did you just go into the car?
No, I don't believe I notified the tow or anything of that nature yet. Or I may have, I don't recall.
Did you ask any questions to the 2 passengers in the vehicle? There was a front passenger and a back passenger. Did you have any conversations with them?
I'd have to look at my body cam to go over like what, if we did have a conversation outside of, do you have any firearms on you, as I was removing them from the vehicle? But I don't recall it, but conversation.
So did you ever ask either the front passenger and the back passenger whether they possessed a firearm?
I'm gonna object whatever the passenger said.
That would be unless it's an exception that you have. In the event that was the next question.
I'm not asking whether they answered or not, I'm asking whether this officer asked a question.
I would assume that I did ask them if they had any firearms on the person, just for my safety and my partner's safety. But as if they owned a firearm or legally possessed a firearm at any time, I don't know if I would ever ask that. But I don't remember asking them exactly what you just said.
So I just want to make it clear. So you said you assumed you did, but you don't remember asking whether the other passengers in the car possessed the firearm.
Right.
What are those passengers' names?
I don't know off the top of my head.
Thank you. Nothing further on.
Nothing further, Your Honor.
Any other witnesses for the people?
No other witnesses for the people, Your Honor.
And no witnesses for defense, Your Honor.
Okay, thank you.
Thank you. Your Honor, people request that, send it down over on count one, weapons carrying concealed, reserve argument.
Your Honor, at this time, we're objecting to the bind over on one count of carrying a concealed weapon. In the first framing of this case starts with why Officer Ely was out in the first place. He was not out doing routine traffic duty. He was out on overtime, and not just any overtime specifically for firearm prevention. Now, the claim from Officer Ely is that as he was driving past, as Mr. Grimes was driving past the intersection, he observed front windows. And that's what triggers the lean search and eventually the stop. I think there are issues in terms of the procedure that was followed, unconstitutional issues, Your Honor, that make it hard for me to believe that this was an inventory search, that this was just a typical traffic stop. Based on Officer Ely's testimony, it's more likely than not that this was a pretty typical sting operation to make sure that there was or was not a gun in the car. And we know that because Officer Ely can testify to the conversations about the gun, but he can't seem to remember, to bring a tow card today, which we need to have to justify whether or not this is an inventory search. He can't remember what he found in the car outside of the gun. He can't remember the names of the other passengers in the vehicle, whether he asked those passengers anything about whether they possessed the gun in the car. I think there was an assumption, and I'll use Officer Ely's words, an assumption that certain things were done, but also a pretty fatal assumption, which is that Mr. Grimes, in fact, was the one who possessed the gun in the first place. What Officer Ely stated was when his partner asked questions about, is there a gun in the car, where is the gun, that Mr. Grimes answered. At no point was there a discussion about possession, which is necessary in this case. If we have 3 individuals in a car, and there's at least one individual, the front passenger, who has immediate access to the center console just like anyone else, there's a question there, Your Honor. It's a question that Officer Ely wasn't able to answer, which is who possessed the gun. If we could have Officer Harris here to speak to more of that conversation, specifically whether Mr. Grimes stated that it was his gun, it wasn't his gun. But from the looks of things, it doesn't seem like it was Mr. Grimes' gun. It doesn't seem from Officer Ely's testimony that this was the car, and we don't know whether or not the registered owner of the car was in the vehicle at all. I think we can look to specifically people v. DeLue. Now that's an unpublished court of appeals opinion for reference docket number 57668, which specifically states that an inventory search is unconstitutional when there's not an actual inventory of property. Officer Ely cannot testify today what was inventoried outside of. Number two, what steps did you take to impound the car? Officer Ely stated directly that he did not take those steps. He went to search the car first and then decide how to impound. That's People v. Matthews, another unpublished opinion from the Court of Appeals, docket number 348155. And it's important, Your Honor, because I understand that there's a need to get guns off the street. I think the Detroit Police Department has made that an explicit policy, but that cannot erode an individual's constitutional rights under the Fourth Amendment. We can't stop cars and then make up reasons after, especially when we can't get clarity when an officer testifies about what procedures did you take to make sure that someone's rights were not being violated in the instant of the traffic stop. For those reasons, Your Honor, we are again objecting to the bind over decision and moving to dismiss counsel. Thank you.
Your Honor, the thing of probable cause, there's definitely question of fact. What we have here is there's no testimony whether or not this was a sting operation. There's no reason why a police officer on duty sees a violation, tinted windows, which is a question of fact, and runs a lien which shows no insurance, which is a crime, and gives a probable cause to stop. As to the inventory search, it doesn't matter if they contacted the impound first or not. And as far as the ownership of the gun, again, that's a question of fact. The testified defendant knew of the weapon. He was in control of the car. He was driving without a license. They had probable cause to stop the car. They had probable cause to impound the car. Also, it was testified that the defendant was reaching in the area where the weapon was. That alone would give them a reason to search that vehicle for officer safety. But they didn't even need that due to the fact they would they were doing an inventory search to impound the car. So there was more enough evidence to find this over on the charge of concealed weapon, and we asked the court to do so.
I do believe this is a question of fact. As a matter of fact, Attorney Roberts, as you mentioned, there are some questions. At the probable cause standard, I believe there's enough testimony today and evidence to bind the defendant over. What we have here is a stop based off of front driver's side tinted windows, which is illegal to have full window tinted in the state of Michigan. The officer's intent as to why he would stop, not on the record, or cannot assume what it is, but that's a lawful stop. So after that stop, it was discovered through asking the defendant and the passengers if there's anything in the vehicle regarding contraband they should know about. The defendant admitted to having the gun in the vehicle. And that gun was found in the middle console. So the second or another issue brought up was possession. And in this case, it would be constructive possession because it was not actually in hand or in person. With possession that's constructive, you have to have knowledge and the ability to control. There is testimony that will lead to a question back to the trial fact. One, the defendant was driving the vehicle. Two, there were observations that the defendant was reaching in the center console area before the defendant admitted to having done that car, which can satisfy the probable cause standard, the ability to possess and the knowledge elements for possessive, or excuse me, constructive possession. And also with the inventory search, I'm not familiar with that case. However, I would argue that common sense, as an officer, I would secure a weapon and you need individuals who may have weapons before calling the tow truck. But that will also be for trial fact to determine. So with that, we found over search at Third Circuit Court for an arraignment on the information date of July 17th at 9:05 a.m. We Frank Murphy Hall of Justice. I don't know if it'll be on Zoom or in person. It depends on which judge you get. Right? Anything else from the party? You might want to talk to your attorney first. But I will let your attorney address it.
It's not.
Nothing further.
All right, nothing for the people. Mr. Sawaki, nothing for the people on.
Nothing else on the ground.
Okay, all right, we're on the record.
Thank you.
Okay, this is case 2356010, the people of the state of Michigan versus Martin Reese II. Reese is charged with count 1. Controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. And count 2, a misdemeanor operating while intoxicated, except for exam appearances.
Good morning, Your Honor. Danielle Parrish from the legal P85495.
And good morning, Your Honor. Chair, that's found P43881, Parrish County Counsel Martin Reese. Second.
Good morning, Mark Reese, second.
Good morning. Okay, I have a waiver form before me. Is it correct to respond that your client is waiving this exam? That is correct. Okay, any objection from the people?
No objections from the people, Your Honor.
Okay, Mr. Reese, I'm going to ask you some questions. If you can't hear me or if you don't understand me, let me know, okay? Did you wish to waive your preliminary exam today?
Yes, ma'am.
You understand that you have a statutory right to a preliminary exam.
Yes, ma'am.
That if you demand that exam today, that people would have to show at the probable cause standard, which is a lower standard in criminal law, but still a standard. That one charge I read off just now was committed in the city of Detroit, that you probably committed. You understand that?
Yes, ma'am.
And then by waiving your exam today, that means that the people do not have to present any evidence at the probable cause standard. Understood?
Yes, ma'am.
Do you also understand that you are not giving up your right to trial?
Yes, ma'am.
Knowing all of that information, you still wish to waive your exam?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam?
No, ma'am.
Did anyone promise you?
No, ma'am.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. You be bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information date of July 17th at 9:05 p.m.
Thank you.
You're welcome. Same thing as I told the last gentleman, I don't know if it's on Zoom or in person based on the judge. Thank you, Your Honor. You all have a good day. You too. Okay, Edward. Okay, we're on the record. This is case 2355576, the people of the state of Michigan versus Anogo Everett, charged with count 1, weapons, firearms, discharge in or at a building, count 2, weapons, stun, firearm, set for a motion hearing. Appearances.
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355. Appearing on behalf of the operator and judge, I would ask to waive for appearance for this morning's hearing.
I will wait for appearances. Okay, last time we discussed, I was on Zoom training and I wanted to be able to address this in person. In the event I had to look at some documents and also for time for the officer in charge to provide an answer regarding whether or not there was any additional discovery digital that was not provided or available. And the officer in charge is here, correct?
That is correct. Officer in charge, Stephen Jackson, is sitting right behind me. Officer Jackson, could you put your name on the record, please? You can stand right here so that's right.
Officer Stephen Jackson.
Good morning.
Good morning.
Now, before I begin, is that correct? Did I summarize correct what the
Yes,
issue is? Okay. So regarding digital discovery, is there anything existing or that you have discovered since the last time you reported or since you provided discovery to the prosecutor that exists that would be relevant, pertinent to this case?
No, Your Honor.
Attorney Phelps, do you have any questions or anything based on?
I do. I don't know if we want to clear him and do my questioning or no. I just want to stay there.
I guess maybe asking you the questions.
Okay,
and then
yeah. Judge, so there were quite a few items that were mentioned in the discovery as far as body worn camera, as in the paper discovery existing. And so my understanding of today's purpose is to try to understand why we don't have those items. When we initially came for the exam, that was the first time that the government learned that I was, that there were specific items that I didn't have. And before that, I had two, I believe 2 files of body worn camera that were provided from some officers. And then there were 6 other 6 other officers who were mentioned as having body worn camera in the paper that we did not receive. And so the inquiry really is, why is it that only the 2 were preserved and then allegedly the rest of them are just gone, when there are DVD policies in place that, all of them should have been preserved, as well as a statute mandating that the DVD keep these files while there is litigation. So those would be what my questions would be about, just to get the specifics here on what happened to this digital discovery.
Your Honor, if I may, just because we are on the record, I want to clarify, as the defense has erroneously stated she only received 2 files. If this is the audit form from evidence.com. It indicates here that she was provided 1, 2, 3, 4, 5, 6, 7, 8 digital files prior to her request on the date of the exam. And those were all uploaded previously in January, and they're not broken up, Your Honor, so it's not like we send them individually. If she received 1, she received them all. So that is what was all in the file prior to the new OIC, who is with us today, uploading additional files, which in my opinion, those files look to be duplicates. I don't know, that to defense, because I assume since, this is her motion, she did review the ones that she received, but, as I said, I have an audit of that. Happy to show you. I just showed defense.
And Your Honor, my apologies, I didn't have written down specifically what I did receive. So what I'm talking about are the items that were requested that have not been received. So I do believe that she's showing a list of some files, I think, and again, I can check mine with my computer cooperates. You know, there were, in my memory, again, this is just my memory, I don't have it open before me, there were about 3 officers that I received their body worn camera from the incident, and then I followed up with what I was missing. And so whatever was received initially was what I received a second time, as APA Parrish noted, a duplicate of those same files. And there may have been, 12 files, but from what I actually saw that were video files that I'm talking about, I believe there were files from 3 officers. And so what I'm asking about are the things that, again, have been noted several times, but are missing, which is from 6 other officers. And again, as we stated last time on the record, there is a spot on the police report where the prior OIC notes that she reviewed all of the body cam footage and placed it on evidence. And so it was the people's position last time that was referring to those files that we received initially, but without any real basis for why they thought it was that. But so anyway, the point is we're still missing quite a lot that's documented in the police report of having existed at some point. So we're just trying to get to the bottom of what happened.
Is there a list of the 6 officers?
I have a list. If I may, I will, for the record, clarify. Prior to, I can indicate, there's 2 files that are listed unknown with the actual numbers. Again, I did not have an opportunity to see exactly, often that is dash cams and whatnot, but it could be additional body worn camera. There's 2 of those.
Okay, so why don't,
I have the record. Again, that's not the issue.
is the anything you know, or have you looked at the?
Your Honor, the day we were supposed to look at them, defense stormed out of the office that I cleared the whole day for us to review which files we had and we didn't. And since we were ordered to do that together, it was her request. To be honest with you, I don't need any of these files to do preliminary exam. She's the one who needs the files, I presume, for trial purposes. And we are trying to do our best to make sure she has everything. At this point, she does have everything. And there is nothing further. I just want to go on the record to indicate that the ones that she asked about specifically, Your Honor, was Officer Nager. She indicated that there is something on his supplemental report that says equipped with body worn camera. Equipped does not mean that it was on, or if it was on, that it was uploaded, but nonetheless, it does say he was equipped with it. Officer Hill, which there is no indication that he had body worn camera.
Let me just stop you here, because there are a couple of things that I got to. Attorney Phelps, is that, I don't have it in front of me, so is that what it says on?
Yes, I'm quoting Attorney Phelps, Your Honor.
Okay.
What is the question? I'm sorry, Judge. Is that?
Because I'm asking who the 6 officers are. That's
Right, so
all I want to know.
Officer Deidre Hill, Jordan Zilkowski, Ravinsky, and Raymond. And if you want me to pull out the different pages of the paper discovery where their parts are indicated, I'm happy to.
You said Zilkowski, who, and Ray?
Zilkowski, Ravinsky, Raymond are the last 3.
Okay, so for those 6 officers, which ones had body cam?
All 6 of them. So just to be clear, Judge, and I'm sorry to belabor this, but so the digital that Ms. Garrett was referring to, that she's received, that she was going to present to me in her office that day, it's all the same digital that I received initially.
Right, so there's no new discovery.
There's been nothing new provided, and so again, it's those 6 officers that we're trying to get to the bottom of.
And I'm hearing from Ms. Parrish that there's, number 1, you said Nader, is that his name?
Yes.
You say quit, but doesn't say that he had body cam.
It says equipped with body worn camera. And so that's, in my experience, you know, again, we would need those officers to be here to inquire into this further, but there should be body worn camera for that person. It says that they got it equipped. The DPD policy has that they have to have it turned on when they're having citizen encounters. This officer was having a citizen encounter, and if it didn't work for some reason, it has to be documented, which is also part of their policy.
Next, Your Honor, just to make this a little quicker, with Officer Nager, Officer Zilkowski, and Officer Raymond, we are not denying that their supplemental reports at the top indicate that they had that they were equipped with body worn camera. We do not disagree with defense that often that means that they're on and they should be running, but it does not indicate that it was properly uploaded or that anybody has that. Therefore, that is why once those three, in addition to the other three that do not have any, I'm not sure what their situation is, but all six of the officers that defense indicated specifically was sent out to the officer in charge to look for those specific. He looked for those, could not find those, so the only thing he could find was the CD that was preserved. Because anything else that was uploaded may not have been preserved, but he did find the CD that the original officer in charge references, that she put all available body worn camera or body worn videos onto the CD. He obtained that CD and he re-uploaded that CD, and that CD had the 1, 2, 3, 4, 5 videos that we are assuming are the same exact as defense says that she already had. That being said, I've been in contact with the officer in charge several times since this and before this. He has checked several times, he can state it for himself, to confirm that that is all he has. I even sent him chasing a different police report number due to the fact that in the reports, it indicates that this incident happened on one day, but that the defendant was actually not arrested because she came back to the incident, the scene of the incident, and then she was arrested when she came back there. And therefore, there was another police report. That is what I believe, for instance, Officer Raymond, where defense requested this officer's body worn camera. That was on a completely different day, completely different police report. And the officer in charge was asked to look that up, and that also, there was nothing that they have currently or that was provided to us. Point being, everything that she requested, there is no actual videos for any of these, whether there was any or not. We do not have any now. The DPD does not have any officer in charge is here to testify to his actions in trying to find them and the results.
Okay, so what is the remedy in this area when a police officer does not upload or start their video and or upload their video if they did?
I didn't hear the beginning of your question, Aaron.
What is the remedy when a police officer does not turn on their video cameras for events?
If they don't turn it on?
Yes. And
I do not know, as far as that would be departmental, if there was any action taken departmentally wise. Discovery wise, if they're.
Defense counsel. I don't care if it's turned
Oh,
on.
okay. Well, it's a discovery issue. That means that there is no video. So there's not a discovery violation. There's only a discovery violation if we actually have video and we're not providing it to them.
Okay, so there was also mentioned that there was video that may not have been uploaded.
If it was not uploaded, it would have been on that CD. Oh,
Preserved, excuse me.
preserved. So if that is the case, that would mean that nobody has it. And that's why we brought in the officer in charge, because he is the only one who can actually look, because we provide everything we have as far as we, when I say we, Wayne County Prosecutor's Office, but I had the officer in charge The new officer in charge, as we stated, he has only been assigned this case as of the day this exam was supposed to transpire, which was almost 2 weeks ago. But he has actually looked beyond evidence.com to see if there is any, and he obtained a CD, and that CD only has those items that.
Right, but I understand what exists is the same thing that's always existed. That does not address what has not been preserved. Because you mentioned it yourself, that it may be some things that were not preserved.
Correct.
That is my issue.
Right, that means there is no evidence, so.
I know, no,
We don't
no,
have
when
any.
it's not preserved, it means that it was evidence, and it wasn't preserved or kept and stored for the case, meaning it did exist.
Your Honor, and you're not wrong, and we are assuming that because neither myself nor this officer in charge, because only an officer in charge uploads, or as you indicated, would preserve. That officer in charge is no longer with the department. So we're really making a lot of assumptions. We could even assume that the officer said the body worn camera was on, but maybe it wasn't operable. But because we don't have that officer in charge, we won't ever know.
And that's not sufficient for someone's life right now.
I understand your Honor.
Liberty and freedom. So the
Right.
first issue is, one, I understand that the probable cause conference or standard, you don't have the time. I understand exactly how it is when we prepare for a case. But defense has made a motion, and I know that you all have some issues off the record, trying to meet together. But for the people to just represent and say, well, I don't know what's on all of this discovery and defense counsel, you know, she can look at it and determine. It's a little difficult for a defense counsel to determine who an officer is on a case, on a body cam, but she's not part of the initial, she has no idea. That would be something that would have to come from the prosecutor's office, from the police department. So to just tell her and just picture evidence to her, give it to her and say that, well, I didn't review it because it's a probable cause standard, but she can review it and kind of guess as to what it is. It doesn't help me because I can't get to an answer because you don't know all of the evidence that exists or did exist. And she's alleging certain things based off of what she doesn't know or is trying to figure out. So I don't know what you expect me to do when I hear that there's evidence that has not been preserved or may not have been preserved, or that there's evidence that you don't know exactly what it is, or what it could be, but defense counsel is saying what it is when she doesn't necessarily know because she's not going to bring the case.
Your Honor, I can easily pull it up right now and confirm within 2 minutes, but as I said, it's not that I don't know what it is, I just didn't watch, Your Honor, 18 hours worth of videos that I was required to watch with her because she didn't want to. That is a separate issue aside from giving her discovery. I agree. We want to provide her everything we have. We are not saying that that there is anything else out there at this point. Even the defense is conceded as to what we have given her. All of these are labeled. I can tell you which officers she gave. And I agree that the officers that she has listed, we have not provided her that because we don't have it. And these are the ones that I asked specifically officer in charge to go and look into. And he himself has indicated to myself that he cannot find any of those and there was nothing further than what we've already provided.
Right, okay, it's like talking to circles. So the part that's already been provided, that's not an issue.
Right.
Issue. It's the 6 officers and the body cam of those 6 officers, whether or not that body cam evidence existed and whether it was preserved if it did exist.
Your Honor, I don't believe anyone in this courtroom can actually answer that as far as what happened. All we can answer is that there is no evidence at this time.
Right, we got that too. Because otherwise we wouldn't.
Right. I wish I could give you an answer. We've really worked diligently on this. Like I said, we've even attempted to go into different police reports. You know, at this point, as far as what has been conveyed to me, as far as discovery requirements, is that we have to provide defense with everything we have, or everything that possibly the police still have that could be presented in the future. And that is why we brought him here to get on the record to indicate if there isn't.
And I know you don't have much information as you were brought on, you weren't the initial officer in charge. So is there any other information you want to provide to the court or defense counsel regarding this discovery?
Basically, what you see is what you get. That's it. That's all that was documented. I don't know what happened. I don't know why the other officers, what they did, if they even turned their body cameras. I don't know. That I don't know.
And this has only been raised, and correct me if I'm wrong, Attorney Phelps, because the discovery pack says that they have body cam.
That's right, Judge. And again, their policy indicates that if it didn't work, and two of the officers, just to correct the previous record, we were talking about three officers where it said indicated, two of those three, it also says on, and then one says on and synced. And so, again, the DPD policy requires that if there is an issue
And they have to
somewhere in
provide
this
a
chain,
report.
then it has to be indicated, and they didn't do that, so.
Is that correct? There's no report from any officers as to why their body cams were turned on?
What was the question?
Is it correct that there is no indication or report or anything in writing from any officers as to why their body cams not turned on?
No, not that I saw. The only indication was a confirmation from the former OIC that all, digital body worn camera was uploaded to the CD, and that is the CD that he provided us.
Oh. All right, so I do not, my issue is always whether or not, when it comes to discovery, if there was evidence that was available and not preserved, one. Also, second issue is whether or not, I guess that would be not as big of an issue, but it's still one regarding the officers not turning on their body cams. That is an issue. Based off of what I'm hearing, I'm going to dismiss without prejudice for a violation of discovery.
Your Honor, I'm sorry, I don't mean to cut you off, but
you are cutting me off. Go ahead.
I'm sorry, as far as we've given, and I'm sorry, again, I apologize, I respect your answer here. We will reissue tomorrow, but this is not a discovery order. We don't actually have that evidence. As far as a discovery order, we've provided in writing the response to defense, and we've also provided with OIC here that there is none. And this will be reissued.
That's the issue. It's not that you all didn't provide what you had. I'm not saying this is a Brady violation. I'm not saying either of you are withholding. The issue is that there's a report that's provided from DPD that says that there was discovery, that there was body cam, but no one can provide an answer as to what happened to the body cam.
Thank you, Your Honor. I appreciate that answer. I would like to just put on the record that this is a crime with a victim, that is for probable cause standards. None of these videos are actually even relevant, not even actually for trial, because the officers she indicated on here are not even officers that can witness or testify to the actual incident that occurred.
So that is why the police department continues to put in the discovery pack that certain body cam is available and relevant if it's not.
Your Honor, they should all, I'm not disagreeing with you, DPD should all have body worn camera. And anytime they come into contact with someone, that body worn camera should be switched on. It should be recorded and it should be uploaded and provided, whether it's relevant or not.
And how can the police department determine what's relevant or not before providing it to counsel? You never know what defense counsel may have in regards to their client. So to say that something is relevant or not before even providing it is also a problem.
I agree with you. I do. I'm just stating that in this instance, there is no additional video. And so I respect your decision. I just want to put that on the record because it will be reissued tomorrow.
Okay. Just that when it comes before the court, if it comes back to us.
Thank you, Judge. And can I wait for, or do you want me to fill out a written dismissal order? Okay, but can I wait for the orders if they're going to reissue? I'll leave that to. Yes. Thank you.
Okay. Madam Clerk.
Attorney Jefferson is on both of the Miller matters, okay?
Okay, thank you.
Attorney Maduro says that her can't be from I'm the guest, right?
How you doing? Yay. What about this McLaurin?
Warren is gonna be kids.
What about this Pat? Pat?
I.
Okay, we're on the record as the people of the state of Michigan versus Jason Miller, case 2258484. Mr. Miller is charged on this case with count 1, retail fraud, first degree, second or subsequent offense notice, with official offender fourth offense notice. Mr. Miller is also charged on 2257124 with 1 count of retail fraud, first degree, second or subsequent offense notice, with the official offender fourth offense notice. Paperwork exam, excuse me. Okay.
Sorry, Mike. Edwin Milwaukee, P5482A, appearing on behalf of the people.
Good morning, Your Honor. Thomas C. Jefferson, on behalf of Jason Miller on both matters before 2872. Your Honor, I've called my client's name out in the courtroom as well as looking for him in the court, in the hallway, as well as looking for him in the courtroom. I have no explanation by his name.
People have heard you, Your Honor.
Okay, I'm going to give you the client. However, what I see here is a history of failure to appear. He was able to post last time 5,000 cash for surety fine. Based on the charges, I'm going to do 5,000 person in the hopes that he will show up instead of trying to find knowledge that kind of stuff. So I'll put in 5,000 first. Okay.
Thank you.
ready on the floor? This is case 2260544, the people of the state of Michigan versus Ronald Lamar Lauren, charged with count 1, weapons carrying concealed, count 2, weapons, firearms, possession by felon, count 3, weapons, found in firearms, second offense, individual offender, fourth offense, that was set for example. Appearances?
Edward Zawaki, P 54828, appearing on behalf of the people.
Good morning, Your Honor. Sabree with the Defender Service on behalf of Mr. Warren, 86432.
And I would like to see Mr. McLaurin with you.
No, Your Honor, I have sent an investigator to his known location. However, he has not lived there for quite some time. I know, or at least I believe he is on tether. I have spoken with Sergeant Robert Hall regarding the tether, whether he knows where he is. He told me to send him an email today, and I did. So he is going to look into that. It is my understanding that also Mr. McLaurin has a preliminary examination in front of Judge Keene on the 12th as well. I was wondering if this court would be so willing as to allow this to be adjourned until then, to see if I can get more information from the tether unit to see where he is. Obviously, he is on GPS tether, so we should at least be able to track him down in some sort of way. So if we could just give him one more chance, I would truly appreciate it. But I understand that any decision you make, Your Honor.
We'll leave it to your discretion.
The case is history.
Yes, Your Honor, I believe he had another case in 2020, but I was not sure of the facts around that one.
Even on this case, on January 3rd, he came in and didn't appear.
Yes, I believe actually he was in custody at the Macomb County Jail. I did speak with him after that, and he called me the day he got out. But since then, I have not had contact with him. Again, I have tried, with an investigator, but now I am going directly to the other unit to see if they can assist in the matter.
So I don't see how we will be able to guarantee that he will be here on the 12th. Tether unit can let you know where he is, but he's not violating unless I put it in papers. How else would he be required to come to court?
Yeah, so I am hoping that if the tether unit gives me a known location, I can send an investigator to that location, and we can be in contact that way.
I'm not gonna adjourn this now, because I do not want witnesses and people coming, changing their whole day for somebody who may not show up for court. I will issue a KPS and be 1,000 personal. And if he shows up on the 12th, I'll allow him to walk in and I'll rate him instead of PCC.
Understood. So then the exam will be pushed back in another day.
Right.
Okay, I appreciate that.
So if he does show up on the 12th, I will allow him to be walked in and rated this work. After he is done, well.
Sure.
Before.
Before? Okay. Okay.
He might, I don't know what charges are in the bond situation.
Yes, understood.
So you should come here before his exam. And I'll arrange it.
Okay, perfect. I appreciate that, Your Honor. Thank you so much.
You are.
Thank you, Your Honor.
Let me see.
You too.
Radio 5?
Yes, Your Honor.
Okay, case 2059131, the people of the state of Michigan versus Marcel Deshaun Pye. Mr. Pye is charged with one count of operating while intoxicated, causing serious injury, set for exam today. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of People P85495.
Good morning, Your Honor. May I please the court, Carolina Sprinkle, P49898, on behalf of Mr. Marcel Pye. Mr. Pye, would you state your name for the record?
Marcel Pye.
Good morning. Everyone ready to move forward?
Your Honor, I apologize. People are unable to move forward today due to the necessary witness that was subpoenaed that has failed to appear.
Your Honor, based on the people's failure to proceed, I am making a motion to dismiss.
Okay, I will dismiss without prejudice.
Thank you, Your Honor.
You're welcome. Shouldn't take long.
Happy safe holiday to you and your staff.
Any further issues today?
Yes, I'm sorry, my client is on an alcohol tether. He's able to have that removed.
I'm going to put it on the dismissal.
Okay. Well, no, you know what, Judge, it's not an alcohol tether.
It's a breathalyzer.
Sober link or whatever this machine that was conditioned by.
Okay. So note that, how do we get rid of it? Turn it wherever it came from, I don't know. Let's see. As part of your dismissal form, you should be able to show all be discharged.
I'm thinking if he shows up with the order,
Yeah.
that should be sufficient.
Should be sufficient. Okay. That is, when's your birthday?
420.
Okay, we're on the record. The people of the state of Michigan versus Timothy James Melvin. 2356997. Mr. Melvin is charged with one count of weapons carrying concealed, set for exam. Appearances?
I went to Walker 25488.
Good morning, Your Honor. Sabree birthday, P81745. On behalf of Mr. Timothy Melton, who is present in the courtroom to my right. Mr. Melton, please state your name for the record.
Timothy James Melton.
Thank you, Warren. Is everyone ready to move forward?
Your Honor, people are not ready to move forward because Officer Dodge is on furlough this week. I did send an email on the 28th to you and I believe this is the defense attorney asking for an adjournment.
I have email here. Okay. No objection from defense counsel.
Your Honor, in that, the defense is ready to proceed today. We are present at the scheduled time. Everyone, all witnesses have been subpoenaed and notified to be here today. We are respectfully requesting a dismissal for defense. The prosecution is not ready to proceed.
Okay, because the people did in advance of today request the adjournment for officer on furlough, I would find the cause. It wasn't done on the day of the exam. If it was the day of the exam, then I would have dismissed, but he provided a request to all parties. And for furloughs, not because the officer just didn't want to appear, I would allow for one adjournment for the people. So this time, we can discuss the date.
Right.
Says here that officers out all week. Is that correct, Mr. Sawan?
That is my understanding, Your Honor.
Okay, so next week.
Okay, Your Honor, I
Attorney
will,
Prepare, you let me know what day.
I'll be out of town next week, actually through the 18th.
How about the 20th?
I'm for counsel, across the street, on the 20th.
You want the 19th?
The 19th, I do have a sentencing at 9 AM, and otherwise I am available.
The 19th at 10?
Can we say 10:30, Your Honor?
Okay, I will charge that to the people, Mr. Melton. For a good cause, I'm going to adjourn.
That's fine.
So it'll be July 19th at 10:30 back here in person.
There's one other issue. And that is, the order allowing my client, to travel out of state. I did submit, Your Honor, my client's, paperwork, showing he is employed as a truck driver, as a ready employment, pending Your Honor's order. Respectfully requesting, that order, if Your Honor so inclined, if any further information is needed.
I signed it on the 22nd.
Was it forwarded? I don't,
Maybe it wasn't sent to you, but it was sent to the teller.
it was sent to the television, so it is.
Maybe it
in
wasn't
fact-
sent to you.
Okay, would it be reflected in the AR? I mean, the ROA?
Let me get it updated our way. Yeah. I'll send it tomorrow way.
Thank you very much, Your Honor.
You want a copy of the bond, of this, it's 3 copies in here, I can just give you a copy.
That would be wonderful, I appreciate it.
You have this copy of the
It gets the yellow, white.
Okay, well. So that's the ROA with it in there as well as the order.
Thank you so very much.
You're welcome. I will see you all on the 19th.
Okay, thank you.
Thank you, Your Honor.
From the record, this is case 2305741. People of the state of Michigan versus Jeffrey Cox, charged with one count of home invasion, third degree, set for exam today.
Good morning, Your Honor. Daniela Sherrick on behalf of the people, P8495.
Good morning, Attorney Sidney Henderson with NDS P84839, here on behalf of Mr. Cox.
Cox is not present.
That is correct, Your Honor. I've not had any contact with Mr. Cox. He bonded out of jail. I'll try to speak with him, and since then, he is in court.
All right, anything from the people? Your Honor, based on the information defense has provided, and it being in the wind, people would ask that there be a KPS and hopes to track them down.
Okay. The incident happened June 16th of this year, right? This is a very recent, okay. All right, so I was looking at if he had any capers. I'll do it first for 1,000, and if he does research this, you can bring him into the courtroom and have him ready.
Understood, thank you, Your Honor.